Hi, and welcome to our webinar, Estate Planning for Parents. We're going to talk about how to safeguard your child's future. So one of the biggest drivers for parents to create an estate plan is the need to designate someone to take care of their children if something should happen to them. This is a huge concern for parents. And when I walk parents through their estate planning process, though, there end up being a number of other issues that they generally find they hadn't even considered. And those are some of the things we're going to be talking about today. So we'll start by talking about the guardian issue. Who will raise your children if you die before they're 18? We'll also talk about incapacity planning and who would take care of your children in the event of your incapacity. Then we'll go to the next topic. We'll talk about distributing assets among your children. And then finally, we'll look at how to leave behind a legacy that your child will remember forever. So let's get started. First, how to choose guardians. So as I said, choosing guardians is an important issue for parents, and it's generally the one that they're most comfortable and know the most about. But sometimes people are unsure who to pick, or sometimes there's disagreement between spouses on who should be nominated as the guardian. It's always somewhat amusing and also somewhat awkward when you're in a client meeting and you realize that the spouses haven't spoken to each other about this issue. And one of them says, "Oh yes, obviously my sister." And the other one says, "Absolutely not. There's no way we would ever leave our children to your sister." So communication here is the key. There's no one size fits all answer to who should be a guardian for your children. A lot of people will automatically choose family members, but there is no requirement that your guardian be a family member. In fact, for some families, there are real issues with specific family members that you would never want to leave your child with that person. And there are techniques that we can use to ensure that that never happens. So 5 things to consider in choosing guardians. And these questions, it's just a way to go through and get you thinking about who would be the best person for your child, whether that person's a family member or not. So first, does your potential guardian have the physical and psychological stamina to raise your child? For a lot of people, particularly when their children are young, they think, well, I'll put my parents down as guardian for my children. And when your children are young, that seems like a good idea. But if you begin to think about how old your parents will be when your children are 18, you might reconsider. You might also reconsider because then your parents, if they're not the actual named guardians, they can continue to be a secondary support system for your named guardians. And they can get to still be grandma and grandpa as opposed to having to be parents for your children. The second question, where does your potential guardian live? Now, moving can be traumatic for some children, even under the best of circumstances. But in the event of your death, is it going to be important that your child grows up in the same area that they're already living in? And this issue really is one that's going to change as they get older and as they're involved in more things. So for instance, in my own estate plan, when my kids were young, we chose a family member who lives in Florida. My husband and I are both from Florida, and that made a lot of sense. But as my kids got into high school, that stopped making sense. My kids have no interest in changing high schools and living somewhere else for 3-4 years. So we updated our plan and named new guardians. And that's something to keep in mind that we'll talk about. It is fairly easy to change the guardian nominations, and it's something that's important to consider on a regular basis. The third question, what are the philosophical, moral, or religious beliefs of your potential guardian? Now, the person that you choose is going to have a huge impact on your child, particularly if your child is young. And if you have certain philosophical, moral, or religious beliefs that you want to pass down, you want to make sure that the person you choose has those same types of beliefs that they can instill in your child as they're growing up. The fourth question is, if you choose a couple to be guardians, What happens if one of them dies or if they divorce? And this is a question a lot of people don't really think about. They think, oh, well, my sister and her husband. Well, you're comfortable with your sister. If something happens, are you comfortable with your brother-in-law to the same extent? If you choose friends, if they divorce or if something happens to one of them, are you more comfortable with one but not comfortable with the other? There are ways to name guardians so that if one of the spouses dies, then that remaining spouse isn't actually the guardian. You go to your next choice. So there are techniques to do this, but it just requires careful thought ahead of time about whether you want the couple to work together as guardians or whether there's really only one party in that couple that you would choose to be a guardian for your child. And finally, the fifth question, who would make the same choices for you as your child? Now, again, the same thing with the moral and religious beliefs. Whoever is raising your child is going to have a huge impact on their life. And these little tiny day-to-day decisions can really make a big difference in your child's worldview. And it's everything from academics to extracurricular activities, dating advice, travel, money management, all kinds of small day-to-day parenting choices that are going to affect the way your child grows up. And so you want to think, who would make the same kind of choices for your child as you would? And in this case, it's really useful to use concrete hypothetical situations. So for instance, if your elementary school age daughter said she wanted to take up a musical instrument, is that something that you would strongly encourage? If your high schooler said, hey, I'm graduating next year and I don't want to go to college, I want to take a gap year and travel, is that something that you would encourage? Or is that something that is it something you'd want your guardian to encourage? So again, who do you think would make the same types of choices that you would for your child? And communication here is key. I will keep saying that over and over. Communication is key, not just between spouses, but between spouses and we provide a form for you to fill out that serves as a memorandum to your designated guardians. And it informs them about what you consider to be the most important considerations and the most important values that you want to instill in your children. And again, choosing guardians is not a one and done decision. It's important to regularly review your estate plan. We recommend that your estate plan be reviewed every 3 years or any time that there is a significant life change, whether that's a large change in your assets, whether it's an additional child being born, whether you move somewhere, every 3 years or any time that there is a significant life change. And it's important to keep in mind that changing your guardians doesn't require rewriting your will. So when you're thinking about guardians, if something happens, if you know that the person you've nominated as guardian, they've gotten divorced or they've moved out of state, don't feel like you need to wait the 3 years, or don't feel like it's going to require going through the entire estate planning process again. It's fairly easy. It's called a codicil. It just attaches to your will and says, I'm changing this one thing about your will. Now, one of the considerations that many parents don't think about when they're considering guardians is that your will, and therefore your nomination for guardians, only becomes effective after you die. Because the guardians are nominated in the will, it means that your designated guardians have no legal authority to care for your children while you're still alive. So if something were to happen and you were to become incapacitated, there's no one with the legal authority in your will. Your will isn't effective. There's no legal authority for your designated guardians to care for your children. So one of the things we like to do is designate temporary guardians. We walk our clients through the same discussion that we've talked about. Now, for incapacity planning, everyone should have 2 documents: the financial power of attorney. This is the document that designates an agent to act on your behalf, giving that person the legal authority to act in your financial and legal matters. And then the second is the medical power of attorney. And this is a person that you designate to make healthcare decisions on your behalf. Now, these two documents ensure there's someone to take care of you. But again, these two documents don't provide anyone the power to take care of your children. So we like to create what we call the Child Protective Plan. And we designate temporary guardians. Now, your temporary guardians need to be someone who are nearby so that they can immediately pick up your children in the event of your incapacity. It needs to be someone that you're confident can be immediately available to care for your child. And these plans, we provide a medical release that allows them to get medical care for your child. And it's basically a safeguard against your children being taken into protective custody. Because unless you designate someone, the only person with the legal authority initially is the state. So both guardians and temporary guardians, it's a way to just ensure that there's a plan in place so that it's the people that you choose who will be taking care of your children. Now we're going to turn now and talk about tips for distributing your assets among your children. Now, many people know who they want to give their assets to. For most parents, it's common to say, I'm leaving everything to my children in equal shares. Often, however, parents don't think about how those assets will be given to their children. So with a basic will, if you die when your children are still minors, your designated guardian will, once they're appointed by the court, will be in charge of all of your assets, and they'll make regular reportings to the court to show that they're using those assets to care for your children. But once your child turns 18, your child will receive a lump sum of their share of your assets. And when I tell people this, they usually pause and take a deep breath and say, wow, when I was 18, I would have been unable to responsibly handle a lump sum distribution. There are ways to keep your child from getting a lump sum distribution at 18, and it's by using trust-based planning. One of the things with trust is that you can hold your assets indefinitely, and you can choose when your beneficiaries will receive those assets. So there's two basic structures that you can do. By virtue of your will. Your will actually says, at my death, I want my assets to go into a trust for the benefit of my children or whoever you're leaving your assets to. Now, because this trust is set up in your will, it will go through probate. All of your assets will go through probate, and probate is a public process. So everything that you own will be inventoried, becomes a public document, and is available at the courthouse for anyone to see. The second type of trust, though, is a living trust, and you can set that up now. And this ensures that your assets remain private, and exactly how much your children are receiving will also remain private. A living trust is something we've talked about before. It's completely revocable, so you can change it at any time. What happens is you, as the owner of the assets, are giving those assets to you as the trustee to be held in trust for you as the beneficiary. Basically, it doesn't change anything in how you're able to utilize your assets. But what it does is it takes them out of your own personal name. So now you don't own them, they don't go through probate, and your trust then is able to pass those down in a very private manner after your death. Now, whether it's a testamentary trust or a living trust, there are different ways that you can structure it in order to pass those assets on. Many people choose to pass on their assets to their children at, we say, ages and stages. Your children can receive the income at the age that you designated. The principal remains available if needed. And then your child will receive outright distributions at the ages you choose. So for instance, at age 25, they receive 1/3. At age 30, they receive another third. And at age 35, they receive the remaining amount. What ages you pick, completely your discretion. I've had one client who wanted their child to think about it as a retirement account. And so it was the ages were much older. It was like 65, 70, and 75 or something like that. The second way that you can distribute these assets that are held in trust is actually making a lifetime asset protection trust. In this case, the principal is held in trust for the entirety of your child's lifetime. Because your child never owns these assets, they're inaccessible to creditor claims, or if your child gets married and divorced, they're inaccessible from claims from divorced spouses. In these lifetime asset protection trusts, you can allow your child to decide who to leave the remainder to, and you can limit their choices. You can say these assets can only be passed down to your lineal descendants, or they can be passed down to descendants in charity. You can also choose to keep the assets indefinitely in trust for future generations. Now, as far as distributions from principal, whether it's ages and stages or during for the lifetime asset protection trust, you can leave guidelines for distributions for your trustee. And this is where you can really begin to share your values and how you can use your finances to really show what your values are. So for instance, some people, education is very important. And most parents, they want their assets to be used to pay for their child's education. But does that mean just a 4-year degree? Or are you willing to have your assets be used to pay for education for as long as your child wants to learn, whether that's a PhD or any other kind of degree? Most parents, they think, yes, I would like to have it down. I would like to help pay for my child's home, a down payment, a distribution of a down payment. But some parents want to put guidelines on how much that down payment can be for, how big that house can be. Other common distribution guidelines, weddings, to pay for your child's first wedding. Particularly for clients who are business owners, they have entrepreneurial values. If their child goes to the trustee, they want principal distributions for business startup costs. And these are all things that we can include in the trust to provide some guidance to your trustees on how you want your assets and when you want your assets to be passed on your children. So remember, there are options that allow you to have control over how and when. Sure that a teenager doesn't receive a lump sum distribution. Now, the last thing that we are going to look at today is how to leave a lasting legacy for your child. According to a 2013 survey, when asked what the most important thing was to pass down to the next generation, Americans ranked values and life lessons as more than twice as important as financial assets or real estate. Now, of course, values and life lessons as intangible assets are harder to pass down than financial assets, and they're getting even harder to pass down in today's society. In the past, extended families tended to live near each other and they'd get together often. And this created informal moments for people to retell the family stories, to talk about what was important to families. And the family history was passed down to the next generation, reinforced by these informal gatherings. With how mobile we've become, though, we've lost these informal moments for family storytelling. We're in danger then of losing these family values, these intangible assets that most Americans think are the most important thing to pass down to the next generation. Traditional estate planning tends to focus solely on financial assets, the physical assets that they pass down to their children. But these types of intangible assets, we wanted to find a way to pass these down, the way for our clients to be able to pass these down too. And so we've developed the legacy capsule. So what's a legacy capsule? Well, it's an opportunity to tell your family stories and to talk about your family values in a recorded conversation here in our office studio. We provide you with a catalog of questions to get you thinking about your values, memories, traditions, things that you consider to be the most important to pass down as your legacy. The questions are broken down into broad categories: life events, both childhood events and events from your adulthood, your personal identity and your family identity, questions about present day you, your interests, hobbies, sports, things that if you were to die today, you'd want your children to know about you. Aging and the future, your thoughts on what it was like to get older, what your favorite ages were, what the things you liked least about certain ages were, and what your plans are for the future, and what you hope your plans for your child would be in the future. And also life lessons and legacies, your family traditions, your individual successes, turning points in your life, your values, your philosophies. So we send this catalog of questions to you, and you should use it as a brainstorming activity to begin thinking over your life experiences and your family stories. And you'll find that certain questions really resonate with you, and the answers to those questions elicit meaningful life stories and explanations about what makes you and your family unique. You'll select 20 questions, the ones that you think best tell your family story and describe the values you want to pass down, and you send those back to us. On the day of the interview, you'll come in to our office, and one of our attorneys uses those questions to guide you and your spouse through a conversation about your family, which is recorded here in our office studio. We also encourage our clients to bring in family or heirloom photos and family heirlooms or mementos. They can hold them up while they're speaking for photos. We will scan them in, and then the video is lightly edited. We will include any photos or pictures of heirlooms on the screen while you're talking about them. And we present the legacy capsule then on a USB drive. And this is a gift that can be passed down to your children and grandchildren that will help them connect to you even after you're gone. Now, some people might feel that their kids simply aren't interested in the family story, particularly parents of teenagers. But according to a 2018 study of families with teenagers and college students, more than 90% of teens and young adults could retell family stories when asked, even if it seemed that they weren't paying attention. Now, there's been a huge increase in interest in knowing your family ancestry. Many people are looking at DNA kits to find out where their families are from. And while DNA kits can tell you what your ethnic background is or who you're related to, it's really the family stories that bring your family's history to light. And that's what the legacy capsule is for, to preserve these stories. It tells you more than your ethnic heritage. It tells you about your family's heritage. So there is a lot more to estate planning than simply naming guardians. And we've been able to go through some of that today. Everything we've talked about today is something we walk through with all of our clients with minor children, and help them consider each of these issues when creating their own estate plan. And then we customize our plans for each of our clients based on their own values and goals. And that way, you can feel secure in knowing that even if the unthinkable happens to you, there's a plan in place to ensure that your child will be well taken care of.